We're going to go ahead and stop the New Jersey LERA chapter there. I'm Emily Smith. I'm the Executive Director of LERA, and I'm going to be moderating the Q&A from today's recorded mock arbitration, which was nothing short of brilliant. Very enjoyable video. Thanks, James. We have with us today James LaRocca. He's the Director of Employment and Labor Law for Gibbons, and he's the employer advocate in our mock arbitration. We also have with us Pat Flynn, who's an attorney and counselor at law, and he's also a union advocate. And we have Will Hartsfeld. He's an attorney, arbitrator, and mediator. These individuals are going to answer some of the questions that we've collected up throughout our session. And I'll go ahead and share my screen with all of you so you can see the questions that we have. So I hope you can all see that now. One of the first questions that we had, and I'm going to ask these questions to all four of our panelists here today, and any one of you can answer, but we won't want an answer from all four. So C. Eker asked, as a non-attorney mediator, do arbitrators always have to have a pre-hearing conference? Are they required? Are they important for video arbitrations?
Yeah, I'm happy to address that. So labor arbitrations typically will have a pre-hearing conference. Nothing's required. In light of the fact, due to the pandemic, there's been these remote hearings. A lot of arbitrators are holding pre-hearing conferences to help the parties get their arms wrapped around the logistics behind it. I've done them remotely, both with pre-hearing conferences and without, and both worked out. I do have a preference for having the pre-hearing conference. I think it's important, and it's particularly beneficial if in advance. Sometimes arbitrators will also provide like ground rules and the rules that they plan on adhering to during the process. So you have a chance to look those over in advance and hash everything out, kind of like we did in that pre-hearing conference that you saw in the mock arbitration.
Thank you, James. To what extent have you used or participated in pre-hearing conferences prior to the pandemic, and what was their importance?
Let me jump in here on this, if I could. I agree with my colleague from New Jersey. I think, though, that having the pre-hearing conference is going to depend a lot on the parties' experiences. Certainly, if the advocates are first-time remote hearing participants, I think it's very beneficial for the arbitrator to conduct a little conference like we saw in this program. But perhaps as we travel down this road a little bit further, the arbitrator may have experience himself or herself along with the advocates with that arbitrator or another arbitrator, and wouldn't necessarily need that particular meeting. But I do think that they are beneficial, certainly when getting started with this setting. And perhaps the best practice would be for the arbitrator to ask the parties if they want to have such a conference. I think that would be the way to go. And then one other thing that came up in this hearing is whether the clients should be participating. Again, I think that's an option that the arbitrator could probably initiate with the advocates. Do you want your clients or not? And avoid the little skirmish that we had in this particular case, which was kind of interesting, but I would try to avoid that.
Understood. So what are your feelings on recording hearings, and who should have access to those recordings?
Well, okay. I think that if there is no court reporter, a recording could be helpful, but again, it depends on the logistics of that and whether that's problematic for whoever is hosting the platform.
And I would jump in here and say that I have strong feelings that I prefer not to have the hearing recorded if there's not a court reporter, because my experience has been there are problems in those recordings. There's crosstalk. You can't tell who is speaking. There'll be times when there'll be a technical glitch and it won't catch all that's said. And it may or may not be useful if someone has just audio recorded it to know when someone shakes their head or nods their head to know what the answer was. And then with the recording through the platform, you don't know when I'm correcting for someone's misstatement. Sometimes I'll mention it when it's a large misstatement, but when someone says Friday and I know they really meant Thursday, I just let that go, versus when somebody else might hear that recording, they wouldn't know that I was making that correction, or someone refers to the respondent and they really meant to refer to the claimant. I let those slide and make the adjustment mentally. So from my perspective, I really prefer not to have any recording, because the court reporter can go back and make those corrections and will put in a notation of a sick or some other notation that someone misspoke when they said respondent and they meant claimant.
The only thing I'd add is, and I agree with both panelists, is one, depending on the platform you're using, and this might come up, I know ethics is part of this series and it's going to be addressed at another date, but just to foreshadow a little bit, I know one issue that comes up, depending on the platform you're using, is where is this recording going? And if we're doing caucuses, for example, with our individual clients, you have to make sure the recording's off. If it's not off, it might get sent up to Zoom, or Zoom might have custody or possession or control of it, and then the issue of whether or not someone waived the attorney-client privilege could come into play. I haven't practically had to deal with that issue, but from a, I guess, kind of academic standpoint, it's something that's out there and something for people to consider as well when discussing whether or not to do an electronic recording.
Those are excellent comments. Some of the things I would not have thought of. So how much interaction with and practice has been required for you to become ready to conduct video arbitration, and how much for the witnesses and advocates that you bring into the arbitration hearing?
So I'm happy to start on that one. I am not the most tech savvy guy, so it did take me some times practicing using it, repetition, and making sure when you're prepping witnesses. I've been doing 2, sometimes 3 prep sessions, not necessarily long ones, but each time making sure that we're doing it and both the witness and myself have a comfort level with the platform that's being used. It's pretty simple layout, but you could easily get stuck if you don't know, where's this button, where's that button disappeared, how do I get it to reappear? Very practical things like that. Just using it over and over again is helpful. The other thing that I would add is in connection with that point is when you're doing these hearings, you really don't have time to futz around with the buttons. It's really important more than ever to be able to look at the witness and see what the witness is doing and not take your eyes off for extended periods of time. So sometimes it makes sense to have another attorney from my office involved so that they could handle some of the I guess buttons and stuff like that in connection with the platform.
I would say in my experience, the actual flow of the hearing has been pretty normal and simplistic. I think it would be monumentally different if I was going to be the host, which I'm not going to be. And so that part I thought was not very difficult. I mean, certainly you have to put up with the little glitches with people getting disconnected or audio problems, that kind of thing. Most of the work seems to be before the hearing, like Mr. LaRocca was explaining, prepping. You need to make sure that your witnesses have decent equipment. They have the proper lighting. You don't want them backlit. Like in the hearing we had today, Mr. LaRocca said, "Hey, this is so dark, I can't even see the guy." And I've seen that problem myself. So you really have to, there's a lot of legwork that gets done, in my view, prior to the virtual hearing compared to an in-person hearing, even though obviously there's prep for that as well, but it's a little different. But once you get rolling in the hearing, I did not find it to be, too difficult at all.
Thank you. Before we move on to some of our questions about the mock arbitration, we had one technical question that came in from the audience. And so D. Thompson wants to know if the recording follows the host on Zoom. If the host moves into a caucus room, will the recording follow?
And it's my understanding that that's accurate, depending upon the settings used by the host. Because the host may have it set so they turn off the recording before they go into a breakout room. And from my perspective, I avoid using breakout rooms. If I need to sequester somebody, I'll put the witness back into the waiting room rather than having to go and create a breakout room, because it's shown in the mock arbitration. It was being recorded in the session where everybody was present, but that it was set to not record when you went into the breakout room, and there had to be a discussion of, do we want to go back into the normal room to record this? So to avoid that complication, I put the witness or whoever else may need to be escorted out of the room into the waiting room where they can't talk with each other, they can't hear what's going on, and continue to let the court reporter, in my ideal circumstances, write down whatever are the objections and arguments about the evidence.
Okay, so now moving on to some of our questions about the mock arbitration that we received. Chip Galagaza would like to know, is it not possible to see the attorney asking questions and the witness on the screen at the same time instead of switching back and forth? And he asked that because when he was watching the mock arbitration, the screen did not switch to the grievant when he gave his answer. And he felt like that lost some of the ability to pick up on the nuances.
I don't know, maybe Mr. LaRocca could tell us if that was just a feature of the recording, because I think in my experience, you could see everybody.
Yes, and it was a feature of the recording. And in fact, while the whole time that I was examining the grievant, I had him in front of me. So although the picture you saw kept going back and forth, that was just the way the recording was put together.
And I would just observe that that's true of other platforms, not just Zoom, but also in Teams and WebEx. You can have the witness and whoever's questioning them and the representative of the other side all on the screen at the same time, so you can be observing all of them when you want to.
Mr. Arbitrator, would you say that you have, if you're using Zoom, do you have to put it on gallery view? And that's how that feature works?
You do use gallery view. I also have a setting so that anybody who's not broadcasting their video is not taking up real estate on my large monitor. And I actually have 3 monitors for me for a hearing, so I can have it spread across and be sure I can see everybody close up, as well as look at documents on one of those monitors. So that's how I do it. And I think that's what most arbitrators are doing these days, so they can be sure and keep their eye on as many folks as possible. And actually, I find it easier to keep an eye on folks when they're on the monitor than when I'm in a hearing room, because in the hearing room, I'm having to move my head around and folks then realize who it is I'm looking at. But they can't tell who I'm looking at when we're doing it by video.
Interesting. So next question, how often do significant technical issues occur in video arbitrations, and what are the most common problems?
I think I mentioned a couple already. You have, audio glitches, and I think you could hear that a little bit on the demonstration recording as well. And then sometimes people just get disconnected.
Yeah. Sometimes there's lag in not only people talking, but as you saw one of the exhibits, the witness I was sharing a document with, I was trying to zoom in and navigate. I was at, a second or two ahead of him. So, there's a technical issue there, which is just getting used to using the platform and waiting another second or two before asking the question. I was zooming in on certain text. I said, "Can you see it?" And he said, "No, you're on the completely different side of the page." But actually, what I was looking at wasn't. We were just, there was just a delay there. And disconnecting problems, to Mr. Flynn's point, those do happen.
And I would just suggest that problems occur in in-person hearings as well, where somebody can't find an exhibit and they need to have it faxed to the hearing, or they only have one copy. And it occurs in both places. And usually the ones in a video conference is an audio, and usually they're easily fixed by having somebody turn off the microphone that they're using and dial in and use their cell phone for the audio, or simply to move their cell phone far enough away from the computer so it's not creating electronic interference.
Great comments. Mickey, did you have a question or a comment to make?
Yes, I wanted to make two comments. One is Zoom has made some recent updates where you can spotlight up to 9 people. And this will allow you to identify, say, the advocate and the witness and the arbitrator on the screen so that they are highlighted. And it's a really nice feature. And all people would see that. The other is, from a recording standpoint, if it's a local recording onto your local computer, then that recording is going to follow whoever is making the recording. And if you don't turn it off, it will record in the breakout rooms. On the other hand, if you do a cloud recording, then the cloud recording will not record in the breakout rooms.
Interesting, thank you. So on to our next question. Is it more, less, or of neutral importance to have a court reporter in the video conference arbitration than in the in-person hearing? For the pre-conference hearing? I'm not sure about that question. Oh, I'm sorry. Is it more important to have the court reporter in a video hearing versus the in-person hearing?
I would say it's equal in my view.
Yeah, on discipline and discharge cases, I typically will not have a court reporter. On contract interpretation cases, I think it's more important to have that. That's my personal preference. Obviously, I defer to my client's desires. But if you're going to have a court reporter, I'd want it, to Mr. Flynn's point, if I'm going to have one, I want one there if it's a remote hearing or an in-person hearing, just the same. And to Arbitrator Hartsfield's point, it's better than relying on the Zoom recording feature.
And from my perspective, I view it as a neutral, with one exception, which is for civil service hearings, which are recorded by some cities as they interpret the statute. In those, I would prefer there to be a court reporter instead of having just an audio recording, because again, of the technical difficulties with those audio recordings, even when it's simply, when we did those in person, was the Civil Service Commission representative having a recorder there that was a digital recorder catching what was said. So that's the only circumstance that I have a preference for having a court recorder.
Thank you. So to our panelists, how concerned would you be that witnesses testifying by video conference would disregard your instructions and refer to unauthorized materials, electronic devices, or other people while testifying? And what is the best way to ensure that does not happen?
Well, I'll just comment here on this. You know, anything's possible. And I don't think you can ever be 100%, guaranteed. But it just seems like most people are going to behave and honor the rules, I think. I mean, I may be naive, but that's my view.
Yeah, I would tend to agree. You have to obviously be on notice and aware. But if situations arise, I thought the arbitrator in the video handled that one situation with the note very, very well. So that's.
I agree with the other two panel members. I do, if I'm swearing in the witness, actually administer a slightly different oath to ask them to confirm that there isn't anybody in the room with them and that they won't seek any help in answering the questions. But from my perspective, when I'm looking at witnesses, I think if somebody was trying to refer to something or was having someone signal answers to them, that I could detect that, because if they're reading something, their eyes are going to be moving. If they're looking at something, they'll be looking down or to the side. And I just don't think that it's as easy as people believe to get away with being coached in terms of being on video. And I would suggest, although I've never had it happen in person, there are ways for folks to be fed an answer in person that I think occasionally occurs with, if you will, speaking objections instead of just the objection. And I've learned how to handle those with cutting those off and then not giving much weight to the answer after the advocate signaled the answer and the objection.
Understood.
And so many of these cases will turn on credibility issues, and it's a huge risk. I think if somebody's going to take that risk to be coached and then be called out on it, when it could completely destroy their credibility and therefore the case. So it's a really a big risk if somebody's contemplating taking it.
Okay, thank you. We have 2 minutes left, so really quickly, is there any kind of arbitration, contract discipline, et cetera, that you feel comfortable handling remotely, or is there a type that you don't feel comfortable handling remotely?
Well, I think at this point, we've got to handle everything we can handle remotely if we want to get something done. That's my view. So I'll just kind of leave it simple like that.
Yeah, if you asked me in April or May, I would have had a strong preference for postponing and not doing it, particularly on a contract interpretation case, not doing it remotely. As I've done them, I've become more comfortable with it. I think you could have a very good, fair, and equally competent hearing doing it remotely. So just using it and getting used to it has been, I think, important to that.
And I'm sure somebody could come up with an example where we might all agree you really need to do it in person. But sitting here, I don't have an example to give. I think you can do most of them by video.
Yeah.
Fantastic. Well, it is 1:29, so I'll thank everyone for attending and remind you that if you need CLE credits, please add your name to the chat list today and say "Better Together" so we know what to search for in the chat log, and send an email note to Moretta Tate, moretta@tate.com, with your bar number and which sessions you attended. Remember that session 3 starts next week on Wednesday at noon Central Time, and we certainly hope to see you back then. The same Zoom link that you're on right now will work for next week's class, and I believe Mickey would like to say a few words before we conclude.
I just wanted to say 2 things. One is thank you for the panel and to Emily and Bernadette for a really good discussion. Really appreciate you taking the time to do that and help us out. The other is, and Emily, could you spotlight Moretta? I just wanted to highlight Moretta is the person that is taking care of the CLE credits, which has turned out to be a fairly big job. So thank you, Moretta. And the other is just wanted to highlight that Moretta has probably been in every office of LERA that there ever was, and has been a long time person that has really been the spark of Houston LERA. So thanks, Moretta, for all your leadership.
I'll second that.